representing both sides of this impeachment trial. While we are a court of record, we are not really strictly a court that maintains a record for purposes of appeal, because there is no appeal in this case. And so therefore, we are blazing a new trail. Though the rules that were mentioned, in my humble opinion, are not applicable to this particular proceeding, because there is no assignment of errors to be thought about for the future, because there is no appeal lying in the decision of this court. Either we pronounce the respondent guilty, or we say he's not guilty, and either side, no appeal lying. The end of the matter will be the verdict of this court. Unlike in an ordinary civil proceeding, civil case, or in a criminal case, if the defendant is convicted, he can appeal to a higher court and assign reviewable errors of the lower court. Or in a civil case, whoever loses in the civil case can appeal the case and assign reviewable errors in his appellate pleading. In this case, there is no appeal. So, whatever we say with respect to the evidence, with respect to the admissibility of evidence, ends there. They're recorded for reference purposes, but the verdict will be rendered by this court on the basis of the appreciation, final and ultimate appreciation of each of the members of the Senate sitting as judges, jurors in this. That's why I called it jurors, because each one of us will form a judgment of this case, of the respondent. Once that judgment is rendered, we count the number of votes that will vote in favor of acquittal, as well as the number of votes involving that will be in favor of pronouncement of guilt, and if it is guilt, whether we attain the two-thirds vote, which is an absolute 16 of all the members of the Senate. So all of these discussions are for our own guidance. But since there is no reversible error in this proceeding, because there is no appeal, we will take the bull by the horn when we reach the bridge, so to speak. Okay?
Thank you.
Your Honor, please.
Mr. President.
We understood the position of the Honorable Presiding Judge, Your Honor, but there seemed to be some plausibility on the statement made by the Honorable Senator Pia and Senator Miriam Defensor Santiago, Your Honor, because what is involved in their articulation, Your Honor, postulation, are merely rules of procedure, Your Honor, yes, not on the validity of whatever judgment this court may render after trial on the merits. The issue that was posed a while ago is what mood must be taken, must be followed in connection with the non-discussion anymore, or non-taking into consideration of impeachment articles 1, 4, 5, and 6, and 5 articles, Your Honor. We have not yet reached that stage, Your Honor, where a judgment on the merits had been rendered. So, the way I understood it, because there is no definite rule in so far as this kind of eventuality is concerned, provided for under the rules of the Senate, Your Honor, then there is no harm adopting the rules of procedure enshrined under our rules of court. I fully agree. I fully agree, Your Honor, to the effect that if there is already an answer, meaning an adverse pleading, then a mere statement on record or an oral manifestation will not be enough for the dismissal or disposition of those abandoned articles of impeachment. Because the law requires, per procedure, Your Honor, that it must be subject to a motion and approval. A motion is not enough, Your Honor. Even a mere notice is not enough in my assessment.
Precisely, I made it clear that there will be no evidence being presented on those articles, and second, there will be no judgment on the pleading. If you remember, I asked that question from the prosecution yesterday. So, but I will not begrudge and take it away from the defense to use whatever material evidence they have with respect to Article 1, Article 4, Article 5, Article 6, Article 8, to be used for the defense of the respondent in meeting the assertions and the evidence presented to prove those assertions as far as Article 2, Article 3, and Article 7 are concerned. In other words, you have the advantage.
Yes, Your Honor.
You have a great advantage.
We are fully appreciable of the gesture on the part of this honorable court, Your Honor.
That's why I warned the prosecution that this is a fatal error that you are committing if you do not watch out.
Mr. President.
I don't have to teach pleading and practice here, but you think about it.
Yes, Your Honor.
Mr. President, one final member,
Yes.
Senator Jingo Estrada, please.
Senator Jingo Estrada has the floor.
Maraming salamat, Ginoong Pangulo. Isang katanungan lang po kay Congressman Tupas. Doon po sa winidro niyong 5 articles of impeachment, yan ba ibig sabihin niyan ay hindi niya na ho ipa-file yan next year kung sakasakaling maabsuelto si Chief Justice Corona?
Mahirap po na tanong yan, Ginoong Pangulo, dahil wala ho tayong control doon sa ibang members of the House.
Alright.
So ibig sabihin, hindi ko po masagot yung katanungan ni Senator Jingo Estrada ng categorical.
Alright. Pwede malaman yung pangalan ng isang prosecutor doon yung Kamerkana na itim? Yes. Sure.
Si Attorney Vitaliano Aguirre II.
I understand he's a private prosecutor.
Yes, sir. May he be recognized, Mr. President?
Yes, please.
Ginoong Aguirre, kanina ho, nung nagsasalita si Senadora Miriam Defensor Santiago, mulat sa poll, nung tumayo si Senadora Miriam Defensor Santiago, hanggang natapos si Senadora Santiago, ay nakalagay po ang inyong kamay sa inyong tenga. At para bagang ayaw niyo siyang pakinggan.
Totoo po yan.
Yan po ay isang kabastusan dito po sa isang miyembro ng hukom na ito. Kung yun po, kung kayo naman po ang nagsasalita at kami naman po ay gumanon, ano ho ang inyong mararamdaman?
Alam po, totoo po yun. Sapagkat nasasaktan na yung tainga ko.
Alam nyo,
Mr. President, point of order.
What's the point of order?
I charge this private prosecutor with complaint of this impeachment court. I have the evidence right here, taken in a video by Senator Alan Cayetano. And to say, nasasaktan ng tenga ko, should have been cause for you to walk out of this courtroom with permission of the court. But you cannot make those contemptuous gestures in front of a judge and get away with it. I submit, Mr. President, that this should be taken up.
To be fair, I'll give the counsel a chance to explain himself.
Your Honor, kasi po, sinasabi ng kagalang-galang na hukom na ngayon lang daw po nangyari na ang isang complaint ay wini-withdraw or ng prosecution or ng sino man. Pero yan po ay natural po yan sa court practice. Nangyayari po yan araw-araw naman nagwi-withdraw ang isang abogado ng kanyang complaint or ng part ng complaint nag-amend. But the fact, Your Honor, please, that this is the first time that I experience in my 40 years of practice na ang isang judge ay nagle-lecture sa mga abogado. Hindi po ata tama yung mga ganun eh.
Bakit hindi ho kayo tumayo nung nagsasalita si Senadora Miriam para mag-object?
Hindi po ako, wala po akong karapatang mag-object sapagkat kung kailangan pong i-recognize muna ako ng kagalang-galang na impeachment court nito upang masabi ko kung anong nasa sa loob ko. Pero nang nandito na po ako ngayon, di sasabihin ko po ang nasa sa loob ko.
All right.
Mr. President, I reiterate my motion to cite for contempt by the impeachment court, not by me, but by the impeachment court. Imagine if all the lawyers did that in front of the impeachment court, if one of the senator judges took the forum to express his opinions. Kasi salungat sa gusto mo, kaya ayaw mo pakinggan. Kung ayaw mo pakinggan, umalis ka sa korte.
Aalis na nga po sana ako eh, kaya lang...
Granted! If that is in the form of motion, go ahead! Nangahamon ka!
Aalis na po ako.
Dito ako nakaupo eh. Gaganyan ka sa akin.
May I suggest that...
And it's on video.
May I suggest that let us be calm in this proceeding and deal with one another in a fashion that will not create an impression before the people that we are not following the right norms. Please
May I say something, Mr. President?
explain yourself.
Kung nakasakit man po yung isang aktuasyon ko po, I really did it purposely. Because totoo naman po na talagang shrill ang voice na nasasaktan ng tenga ko eh. Ang kuwang ko lamang po ay dapat po lamang na kahit ang mga senadore, mga judges at kami mga hamak lamang prosecutor dito, ang pinaka-importante po sa isang tao ay respeto. Ang nagdedemand, kung nagdedemand ka ng respeto, dapat respetuhin mo doon itong mga abogadong ito. Habang sapagkat yung human dignity, wala pong
Now
katulad
he's
dyan.
lecturing me.
Trial suspended for several minutes.
Sa kasalukuyan.
Pansamantala pong sinuspinde ang paglilitis habang medyo nagkaroon ng mainit na pagtatalo dito sa loob ng Senate Session Hall. They moved to cite for contempt itong isa sa mga private prosecutors, si Attorney Aguirre, dahil Gio kanina habang nanonood tayo nga ng mga manifestations ng mga senator judges ay kitang-kita naman sa ating camera at nagtatanungan nga tayo sa ating amongst ourselves, Gio, kung sino ba itong prosecutor na ito na talagang nakatakip ang tenga at kapansin-pansin naman na tuwing matatapos magsalita ang Senadora Santiago ay tinatanggal naman niya itong kanyang kamay mula sa kanyang tenga.
Maraming nagtatanong, Kasi parang nung napatayo si Senator Judge Jinggoy Estrada, ang una niya sinabi ay, syempre nag-clarify siya kung bakit kay Senator Miriam at singled out yata si Attorney Aguirre sa pagtakip ng tenga sa tuwing nagsasalita si Senator Judge Miriam